Viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters. Matters ranging from immigration law, family law, criminal law. So whatever your legal questions are, please do get in touch. Two ways to get in touch. You can ring on the landline number which appears at the bottom of the screen, 01924 231 083. Or there's a mobile number there where you can send your messages, 07950 797 017. So two ways to get in touch. Now, we get a lot of calls or messages on this show, which is fantastic. Please do continue to send those questions in. When I receive your questions, if it's the case that your matter is quite complex and I need to look at your documents before I can advise you properly, or if it's the case that it's just a complicated matter where you need to speak to me off air, that's not a problem at all. I can speak to you off air as well. And that's a service that we provide completely free of charge. So even if you need to speak to me off air, that's not a problem. We can have that discussion off air as well. Now, we've had a couple of questions coming in. One of the first questions that's come in relates to how to make a visitor application. It's a popular topic in practice. A lot of people in the UK obviously have family members who are abroad and they wish to sponsor them to come to the United Kingdom. So it's really, when you're here in the UK, what you're looking at is how can you make an application, a successful application, so that they can visit you in the United Kingdom. There are two ways of dealing with this. One is to look at what kind of matters, what kind of documents do we need to prepare for the United Kingdom. So these are the documents for the sponsor in the UK. And then the other matter is the documents that you need from abroad. So normally this topic, when we're looking at a visitor application, normally the best way to look at it is to look at what documents do you need from here, and then to look at separately what documents do you need from abroad. So the UK documents are really going to be the documents relating to the sponsor in the UK. Now, as far as the sponsor is concerned, mainly these are financial documents that you need to gather. So the sponsor in the UK is going to be sponsoring the visit from abroad. And what the sponsor will need to show is that there is sufficient savings, there's sufficient income that the sponsor has in order to sponsor the family member from abroad. So the type of documents that the sponsor will be gathering from the UK is going to be as follows. They're going to be showing their status in the UK. So the status is normally that of that they're British citizens or they have indefinite leave to remain. So they will submit their documents showing their status, that they are either British or they have indefinite leave to remain. Now, that isn't to say that somebody who's got limited leave to remain can't sponsor somebody from abroad. But generally speaking, what you tend to find is when there's a couple, at least one of them is either British or has indefinite leave to remain. And you're showing the Home Office that the person that is sponsoring the visit, the person who from abroad is coming to visit, is somebody who has status in the United Kingdom, whether they're British or they've got indefinite leave to remain. So it's not somebody who is an overstayer or anything of that nature. So that's the purpose behind submitting a copy of the passport. The second document that you'll be submitting is going to be evidence of income, because the sponsor in the UK is going to be sponsoring the visit from abroad. So the Home Office will want to know that the sponsor has sufficient income and savings in order to sponsor the visit from abroad. So normally you'd show that there is income being received by the sponsor here. So how do you is concerned, you would normally show your last 3 months or your last 6 months of pay slips. So that's what's going to show that the sponsor in the UK is earning the right level of income in the United Kingdom. So the pay slips are there to show that there is sufficient income that the sponsor has in the United Kingdom. In addition to that, the sponsor will have to submit their bank statements as well. So the bank statements will show receipt of income coming into the bank account and will also show that there is sufficient savings there in order to sponsor the family member from abroad. So you've got the wage slips there, and you've got the pay slip, the bank statements there as well. So it's showing that the sponsor has the ability financially to sponsor the family member from abroad. In terms of the bank statements, what I tend to advise clients is that they should normally have savings of approximately £2,500. That's normally sufficient to cover the cost of a trip from the UK, abroad to the United Kingdom, and it would be enough to meet expenses of the living in the United Kingdom, and it may be a trip spanning a couple of weeks to a couple of months. But normally £2,500 is normally a good amount of money, good amount of savings that a sponsor can have in their bank account. Now, in addition to that, so we've shown the status of the sponsor in the UK, we've shown that the sponsor is earning money and has savings in their bank account. In addition to that, you also want to show that accommodation is available for the family member who is coming from abroad, because obviously the family member needs a place to stay. Now, the Home Office doesn't normally look at this in any great detail. As long as the sponsor is able to demonstrate that there is accommodation available, you might have to demonstrate how many rooms there are, how many people live at the property, but generally speaking, accommodation for a sponsor does not normally cause a problem to the visitor application. As long as there is some space available for the visitor who's coming from abroad, that's normally not a problem. Now, so that's a brief overview of the kind of documents that the sponsor is going to be providing from here. Now, obviously, there may be circumstances where the situation is slightly different. For example, the sponsor may be self-employed. Now, if that's the case, there are different documents that you would then be getting together. It wouldn't be just wage slips and bank statements, because that may not apply to a sponsor who is self-employed. It may be that you need to get, for example, a tax return, financial accounts from the accountant, SA 302. So depending on the sponsor's financial circumstances, the kind of documents that you need to provide may well be different. So it's not the case of one size fits all. Depending on your circumstances, you will then submit documents that meet the requirement that the sponsor can maintain and accommodate the visitor from abroad. So that's a good overview of what the sponsor needs to be doing. Now, in my experience, the reality is there's normally no problem with the sponsorship. Sponsors earning money, there's enough money going into the bank account, there's some savings there. That's normally sufficient for the sponsorship to be acceptable to the Home Office. The major problem really relates to the applicant's documents. The person who's abroad, it's their documents which is the main matter that needs to be taken into account, because that's where most of the applications are either granted or refused. And just before I came on the show today, I was looking at a client who sent me a refusal. And obviously, as I've said, Nothing to do with the sponsor in the United Kingdom, everything to do with the applicant's documents. The best way to look at it is, what evidence that does the applicant have that he or she will go back to their home country? And once you look at it that way, what you're trying to demonstrate is evidence which backs that up. So, for example, if the sponsor is married, that's a plus point. That's something that can also be mentioned, that there is a spouse there. That's a plus point. And if the applicant is coming to the United Kingdom on their own and the spouse will still be abroad, so that's a tie to their home country. That's something which will make the sponsor go back to their home country, the fact that there's a spouse there. Equally, if there are children there, then and they're not coming to the United Kingdom, the children will be a factor which you can show that will make the applicant go back to their home country. For example, the spouse is there, the applicant is there. They're the ties, immediate family ties with one's home country, which are really strong indicators that somebody will go back to their home country. So family is one of those issues that you need to look at. The other thing that you need to look at would be the financial circumstances of the visitor who's coming to the United Kingdom. The position that the Home Office takes is that if the sponsor, the visitor is reasonably well off, then they're more likely to go back. So you need to demonstrate quite clearly what their income is. That depends on whether they're employed or self-employed. What level of income do they have coming in? You need to demonstrate that in black and white. And unfortunately,
Sainsbury's? Oh, we made our money.
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
goes into matching prices.
Remarkable, we've actually come in under budget.
Get it now?
Already got it.
Sainsbury's, good food for all of us.
Our generation's risk of illnesses, like measles and whooping cough, is rising.
If we're not vaccinated,
We're not protected.
and could get seriously ill. Risking lifelong disabilities.
Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Oh, we made our money.
Hey Sainsbury's, explain it, will you?
well. The same effort we put into our baking
Goes into matching prices.
Remarkable, we've actually come in under budget.
Get it now?
Already got it.
Sainsbury's, good food for all of us.
Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. Just how to make a successful visitor application. And one of the factors that we were looking at was what the person who's applying from abroad, the kind of documents that they need to get together from abroad. And the point that I'd reached was in relation to the applicant, the visitor's financial documents. Most of the applications which are refused are normally refused on finances. So it's not normally the case that the person who's abroad isn't working, has no income, they don't have financially, they're not very well off. That's not normally the case. The problem normally is that it's the problem with being able to document one's income abroad. So if I give an example, it may well be that somebody is employed, but they don't receive their income in their bank account, or that they are self-employed, but the Home Office won't accept the financial documents which are submitted showing self-employment because it may be that it's difficult to tell where the income is coming from for the business. The Home Office may not accept the accounts, the tax documents which are prepared in one's home country. So the problem isn't necessarily that the visitor from abroad isn't earning money. The problem is the inability to demonstrate the income in black and white in the kind of way that the Home Office wants. That's where the problem lies. But finances is one of the major issues that you need to look at. Showing that you've got your family, your spouse and your children in your home country, that's just one point. You do need to demonstrate that financially you're well off. That's a very strong indicator as far as the Home Office is concerned of the fact that you will go back. Thirdly, it may well be that you've traveled to other countries and you can demonstrate a pattern of travel, especially if it's to certain Western countries. That will be a plus point in your application as well. So if you've traveled to, for example, Canada, Australia, US, Europe, that's seen as a plus point. You've traveled there and you've returned to your home country. So in my experience, it's not normally a problem with the sponsor who's here in the United Kingdom and the sponsor's documents. The problem really is to do with the visitor's documents. It's how do you demonstrate a visitor will go back? Their family connections to their home country, their finances, which will make them they live in comfortable circumstances, which will make them go back. And if they've traveled extensively, certainly to Western countries, that's a good point to include in your application. It shows that a person will go back. Fourthly, it may be that you have certain assets. So you may own various properties, there are various investments, various pieces of land that may be owned by you, evidence of that, if that's included. Again, that shows something that would make you go back because you're well off and you've got assets in your home country. I think the difficulty arises where, because of the visitor's circumstances, they're unable to, demonstrate these things: family, income, extensive travel, and assets. They're unable to demonstrate these things in their home country. So, for example, if you take the example of somebody in their late 60s, 70s, whose partner has passed away and whose children have now grown up and they may well be in the United Kingdom. So you're looking at how do you demonstrate their links to their home country. The problem is they're on their own. Their children have grown up, they're not dependent on them. They may well be in the United Kingdom. So on the family front, we can't do anything. On the financial front, if they're in their late 60s, they're probably retired. They may not even be receiving a pension. It may well be that their children from the UK are looking after them financially. So, on the financial front, we don't have any documents that we can submit. It may be that they really don't have any extensive travel at all because all they've done is lived in their home country. They might have traveled maybe to Saudi Arabia for Hajj or Umrah. They might have, traveled to neighboring countries, but not to any Western countries. So that doesn't help. It may well be that they don't have any assets in their name either. So the problem is that there are certain types of cases where it is very difficult to satisfy the Home Office of the visitor, the applicant's circumstances. But you have to do the best you can. So, for example, an elderly person whose partner's passed away. It may well be that they've got children who have grown up who are still there. They might have a daughter there, a son there. They might have uncles, aunts, cousins, nephews there. You could always include evidence to demonstrate that yes, we do have extensive family in our home country. In terms of income, if the money is being sent from the sponsor in the UK, you could demonstrate that, at least demonstrate a consistent pattern of money being received in their home country. In terms of travel, that is what it is. Whatever they've traveled to, they can show, look, we've traveled. Traveling does to some extent also show that you must be reasonably well off to be traveling. And it could well be that there are certain historical pieces of land that the visitor owns. You try and put evidence in there as well. So you try and make the best of it. You try and make it as strong as possible. So that's basically how you put together a visitor application. There are certain documents that you need from your sponsor in the UK, which I've outlined initially. And the most important thing is the visitor who's applying from abroad. The visitor's documents have to be strong. What you're demonstrating is everything that points to the visitor going back, everything that points to the visitor having ties to their home country. So I hope that answers your question. Got another question looking at spouse applications and in particular the financial requirement. And the question is, if you are looking at submitting a spouse application and you are employed, what kind of documents do you need to submit? Is it 6 months of documents or 12 months of documents? This is a very common question. If you're making a spouse application to sponsor your partner from abroad, your husband or wife to come to the United Kingdom, then as a sponsor, what type of documents do you need? Well, there are specific rules governing how you demonstrate the sponsor's financial circumstances. The rules relating to where the sponsor is employed, separate rules relating to self-employment, different rules relating to other sources of income. So really you need to look at how the person, the sponsor in the UK is earning their money. Now, in this particular scenario, this particular question that's been put to us, the sponsor is employed. Now, the rule is that if you have been employed, the sponsor has been employed for a period of 6 months with the same employer, then the requirement is that 6 months of payslips and 6 months of bank statements are sufficient to demonstrate the income of the sponsor in the UK. If, however, the sponsor has not been employed for at least 6 months, they've only been employed, for example, for 3-4 months, this is a new job that they've started, they've previously been employed elsewhere, then you need to put together 12 months of documents. So it could be, in the example that I've given, it could be 9 months of documents relating to the previous employment and then 3 months of documents relating to this particular employment. So where the sponsor hasn't been employed for a period of 12 months, you can then, a period of 6 months, you can then show your income over 12 months. So in answer to your question, whether it's 6 months of evidence, whether it's 12 months of evidence, that really turns on how long the sponsor has been employed by the employer. Less than 6 months, then you show your income over 12 months. If it's more than 6 months, then you can show your income simply over 6 months. So that's basically how the requirement for the sponsor's finances is fulfilled. And in terms of documents, the documents are the employer's letter. If it's one employer's letter. If it's 2 employment, for example, spanning 12 months, then it'll be an employment letter from both jobs. It will then be all the wage slips depending on the period that we are relying on, whether it's 6 months or 12 months. It will then be bank statements for 6 months or 12 months showing receipt of that income. So that's what you're basically looking at in terms of the sponsor's finances. It depends on how long the sponsor has been employed by the current employer. That determines the length of the period that the documents need to cover. Thank you very much indeed for that question. Another question relating to spouse visas which are granted. And our brother says, Assalamu alaikum. Would you be able to explain whether the partner visa that my partner has been granted is on the 5-year route or the 10-year route? When does my partner qualify for indefinite leave to remain? Now, the major difference between these two routes is that where a person is an overstayer or where the person making the application doesn't fulfill all the requirements, finances, English, etc., then they will be placed onto the 10-year route to settlement. Where it's a normal application and there's no issues relating to finances, English, etc., then the application will be under the visa will be under the 5-year route. So that's what you basically look at, whether it's the 5-year, whether it's an application from an overstayer or somebody who doesn't fulfill the requirements. That's going to be the 10-year route, whereas the proper application, the person isn't an overstayer, the person fulfills the requirements whenever they've applied for the extension. That's going to be an application or a process which is under the 5-year route, which will lead to settlement much more quickly. So that's the major
Sainsbury's. Are we made of money?
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses,
Like measles and whooping cough, is rising. If we're not vaccinated,
we're not protected.
and could get seriously ill, risking lifelong disabilities.
Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Are we made of money?
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Assalamu alaikum, welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. Just before the break, we were looking at a query that had come in relating to somebody who wanted to know the difference between a visa which has been granted under the 5-year route and a visa that's been granted under the 10-year route. The major difference is that if you've been granted a visa under the 5-year route, then you will qualify for indefinite leave to remain after 5 years. If you've been granted a visa under the 10-year route, then it's going to take 10 years before you qualify for indefinite leave to remain. When you apply for an extension, if you are applying under the 5-year route, then the type of document that you need are going to be different. Under a 5-year route application, you will need to demonstrate that your income is correct. So if you're under the old £18,600 requirement, then you will need to demonstrate that you're meeting that requirements. You submit the right documents in order to qualify for the extension. If you are if you've been granted a visa under the £29,000 requirement, then at the extension stage, you will need to demonstrate that your income is enough at the £29,000 mark in order to extend your visa under the 5-year route. Now, if you are unable in most cases to meet that financial requirement, then you would normally be placed on the 10-year route to settlement. So, for example, just before the application, somebody's lost their job, or they've not been able to work, or they're working but not receiving enough money, then if they make an application to extend their visa, that visa is going to be granted under the 10-year route. Now, the key thing really is this. Under the 10-year route, you would normally need to have children under the age of 18 for that application to be granted. Now, there are cases where applications are granted even where there are no children. So the applicant applies, they're a couple, the applicant applies for the extension, they're not meeting the financial requirement, but there are no children. The Home Office does have discretion to grant leave to remain in that situation as well. But the problem is it doesn't have to. So it's very important where there are no children under the age of 18 that the financial requirement is met, because the danger where the financial requirement isn't met is that the applicant could be required to go back to their home country and to make a new application from there. So that's really the difference between the 5-year route and the 10-year route. It's the time period that you have to cover in order to get indefinite leave to remain. The 5-year route is normally where there's no overstaying and the requirements are met as you go along the process. The 10-year route, on the other hand, is where somebody's an overstayer and they've been granted a visa, or once they're granted a visa, when they're applying for an extension, it doesn't meet the financial requirements. So hopefully that answers your question. Now, the next question that we've got is in relation to indefinite leave to remain. And the question from our brother is that my wife came to the United Kingdom in March 2019. Is she now eligible to apply for indefinite leave to remain? And what kind of documents does she need to submit? Okay, so once you come to the United Kingdom with a partner visa and you've completed your 5 years in the United Kingdom under the 5-year route, you become eligible to apply for indefinite leave to remain. It doesn't matter that your visa hasn't expired yet and you've got another 6 months, couple of months, whatever, to go on your visa. As soon as you've completed 5 years in the United Kingdom, you are then eligible to apply for indefinite leave to remain. What are the requirements? The requirements are going to be more or less the same as what you've been meeting as you've been going along, except that the requirement in relation to English is different. So the requirement in relation to income is going to be the same. If you're on the £18,600 requirement, which most people still are, obviously, then at the indefinite leave to remain stage, you're going to have to demonstrate that your income meets the £18,600 requirement. And as you've gone along the process, you would have, demonstrated that you're living together. So in the same way, at the indefinite leave to remain stage, you demonstrate that you're living together. You show evidence of cohabitation, so that will be documents received by both of you at the same address. So we've got that as well. The key difference at the indefinite leave to remain stage is that you have to show that you meet the English requirement at a much higher level. And what you need to do is pass the Life in the UK test and also pass the B1 test in English in speaking and listening. So if you look at it, if you look at this journey that you've gone through from applying to come to the United Kingdom to get into the indefinite leave to remain stage, there are different levels of English that you've had to meet. At the initial stage when you've come to the United Kingdom, there's a test that you normally do at A1 level. At the extension stage, you do a test at A2 level. And at the indefinite leave to remain stage, you do a test at the B1 level. So that's at the highest level. And then in addition to that, you also have to pass the Life in the UK test. So this is questions that you have to answer in relation to the United Kingdom. So it's knowledge of the United Kingdom. One is the B1 test, which is your speaking and listening ability, which is being tested. And the other is your knowledge of the United Kingdom, which is being tested. So that's the key difference at the indefinite leave to remain stage. You're showing your English at a much, you're demonstrating your English ability at a much higher level. Most people, I tend to find, once they've completed 5 years in the United Kingdom, they are able to fulfill that requirement. Over the 5 years, their English normally has improved to such an extent that they are able to pass the B1 test. And hopefully, over the 5 years, they've picked up enough things and maybe they've studied a bit, so there's enough there for them to be able to pass the Life in the UK test. Now, what happens if you're unable to meet the language requirement? Then what I would advise is that you should try and ensure that you meet the financial requirement. If you meet the financial requirement, at least in that situation, if you meet the financial requirement, at least in that situation, if you weren't able to meet the English requirement, you will get an extension still on the 5-year route. So they won't move you onto the 10-year route. And the advantage of that is, if you stay on the 5-year route, you will be able to qualify for indefinite leave to remain as soon as you pass the English language test and the Life in the UK test. So that's the big advantage of, if you don't, by the time you complete 5 years, if your English isn't good enough, still try and stay on the 5-year route, so that as soon as you are able to meet the English requirement, you are then eligible at that stage to apply for indefinite leave to remain. The problem is, if you at that stage don't meet the financial requirement, you say, you know what, I can't pass the English test. I'm not too bothered about the financial requirement. I'm not going to get a job. I'm not going to earn up to the required amount. The problem then is, what the Home Office will do is, after 5 years, they can still place your partner on to the 10-year route to settlement. So it literally then means you've done 5 years, you're going to have to do another 5 years in order to qualify for indefinite leave to remain. Contrast that with what I've said. If at that stage, okay, wife can't pass the English test, but your finances are right, you demonstrate your finances, that's helpful because you can still stay on the 5-year route to settlement. So I hope that answers your question. The next question that we've got is in relation to nationality. And it's a question that actually comes up in practice quite a lot. The question is, once indefinite leave is granted, how soon after that can you apply for British nationality? And I think in practice, the reason that this question comes up a lot is because it depends. There's no straightforward answer. The position really is this, that if you're married to a British citizen, then you're able to apply for citizenship as soon as you obtain indefinite leave to remain. However, if you're not married to a British citizen, then you do need to wait 1 year before you apply for British citizenship. So in terms of when you can apply, that really depends on who you're married to. If you're married to a British citizen, then you can make that application straight away. If you're not married to a British citizen, then you're going to have to wait a year before you make the application. So that, in a nutshell, is the position. It's who you're married to. Now, in practice, what you tend to find is that those who have come to the United Kingdom on a spouse visa, they're normally married to British citizens. Now, that's not always the case, but in the vast majority of cases, the partner is British. Straightforward, they will apply for British citizenship as soon as the indefinite leave to remain is done. However, let's say somebody is married here on a skilled worker visa. They've got a partner as well, but they've come to the United Kingdom, they're the main applicant, they've completed 5 years under the skilled worker route, they've got their indefinite leave to remain. Now, in that situation, there normally will not be a partner who is British. So that person would normally have to wait a year before they qualify for British citizenship. So it really does depend on your circumstances. It is confusing for people because they hear some people having to wait 1 year, some people applying straight away, and they don't know which way they're going. The key thing is this: once you do obtain indefinite leave to remain, you are eligible to apply for citizenship straight away. If your partner's British, if your partner's not British, you're going to have to wait 1 year before you apply for British citizenship. If you're not sure, you should always take advice from an experienced immigration lawyer who can advise you properly. We're going to be taking a break. After we come back, we'll look at the requirements for nationality in a bit more detail. Inshallah, we'll be back in the next couple of
Sainsbury's? Oh, we made our money.
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses.
Like measles and whooping cough is rising.
If we're not vaccinated, we're not protected. And could get seriously ill. Risking lifelong disabilities. Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Oh, we made our money.
Hey Sainsbury's, explain it, will you?
well. The same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Assalamu alaikum. Welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. Now, just before the break, we were looking at nationality applications, and in particular, when you are able to apply for British nationality. Do you have to wait a year after you obtain indefinite leave to remain, or can you apply straight away after obtaining indefinite leave to remain? So we covered that topic. Now, the other thing is we were looking at what are the other main requirements that need to be fulfilled when you apply for British nationality? Now, there are various rules relating to British nationality. What I want to do is look at some of the key issues that you need to bear in mind. Now, one of the things that will come up is you've got your indefinite leave to remain, you've waited 1 year if you need to, or you're applying straight away because you're married to a British citizen. That's fine, straightforward. What do you need to look out for? What normally goes wrong with these applications? One of the first things that you need to look out for is absences. So check your absences. The Home Office looks at absences in the last year before you submit the application. So that's one thing that they look at. What were your absences in that final 12 months before you submit the application? And the Home Office then also looks at your absences over the last 3 years or 5 years, depending on whether you're married to a British citizen or not. So in the last year, you can't have been absent from the UK for more than 100 days. So if you've been absent for under 100 days in the last 12 months, you're fine. So a lot of people tend to go back to their home country and, they've got the indefinite leave to remain, they go back. You've got to be careful. If you've gone back for a long period of time, then that could have a detrimental impact on your nationality application. So look at how long you've been absent for. Absences of up to 100 days. When you look at the guidance, it refers to 90 days. But the reality is, there's other guidance which says, and this is the correct position, up to 100 days of absences will be disregarded. Then in terms of overall absences over the last 3 years or 5 years, generally speaking, absences of around 3 months per year are normally acceptable. So if you're applying and having to show your income over, your absences over 5 years, total absences of up to 480 days will be disregarded by the Home Office. So one of the key areas where people go wrong is that they haven't counted their absences. And then when you count your absences, you realize that you might be over. So that's one of the key things that you need to look at, absences. The other thing, again, this is relevant, is criminality. If you've been convicted of a criminal offence, normally, in most cases, it's not really criminal offences as such, they're motoring offences which cause a problem. It may be there's a motoring matter which is actually a bit serious and it's gone to court. And because of that, the court's given points and a fine. Now, not a major crime as such, it's a motoring matters. And a lot of the times when you're taking instructions from clients, they omit to tell you that, because you say, have you committed any criminal offences? No, they don't consider a motoring matter as a criminal offence, but it is. If it's gone to the magistrate's court and you've received a fine, that could potentially prevent you from applying for British nationality. So you have to look out for these minor little things, things don't appear major as such, motoring matters, but that could cause you a problem when you apply for British nationality. The other thing that you need to do, it's not a common problem as such. You will need to get 2 people to confirm your identity. One has to be a professional person, such as a doctor, a pharmacist, a teacher, etc. The other person can be anybody else, as long as they're not related to you. Ideally, they should be British citizens, friend, neighbour, work colleague, etc. It could be another professional person as well. So that's the 2 referees that you will need. So nationality applications are, generally speaking, very, very straightforward. A lot of the times I advise clients that, look, you know what, you've been through the immigration process. A lot of the applications that you've submitted might have been quite complicated, but when it comes to a nationality application, they are reasonably straightforward. You could actually attempt the application yourself. However, having said all that, if your circumstances are unusual at all, whether there's issues over bad immigration history, issues over debt, criminality, issues over absences, then obviously at that stage you do need to take advice from an experienced immigration lawyer who could advise you on whether that application is likely to succeed or not. But thank you very much indeed for that question. Now, one other question that we've now got, let's just have a look at it. It relates to skilled worker visas. A lot of people are obviously in the United Kingdom on skilled worker visas. Now, if you're here in the United Kingdom on a skilled worker visa, the question is, and you've done various different jobs as a skilled worker, can you combine that to qualify for indefinite leave to remain after 5 years? What if you've been on different visas, a spouse visa, then you've gone on to a skilled worker visa? Can you combine those 5 years to qualify for indefinite leave to remain? Interesting question. Again, this is something which comes up in practice quite a lot. Which types of leave can be combined to qualify for indefinite leave to remain? So this is really a question not over somebody who's completed 10 years in the United Kingdom. It's really about somebody who's completed 5 years in the United Kingdom. And what they're looking at is seeing whether the different periods of leave can be combined in order to qualify for indefinite leave to remain. Now, the general position is that you can't combine leave in the UK as a spouse with leave as a skilled worker. So you can't combine spouse and skilled. It's got to be skilled worker visa over the 5 years. Now, if it's the case that you've held jobs with two different employers, so you've had two different certificates of sponsorship, one from one employer, which might cover you for a couple of years, another from another employer, which might cover you for another couple of years, that's not a problem because the category is the same. You're able to combine that and show your 5 years in the United Kingdom as a skilled worker working for two different employers. That's not a problem. But what you can't do, generally speaking, is combine different categories to come up to your 5 years. Now, having said that, there are certain categories where you can, normally they are sort of work type categories where you can combine two different types of categories, whether it's, for example, I think sole representative or entrepreneur along with skilled worker. So there are certain categories that you can combine, but they're normally business work type categories which you can combine to qualify for if your 5 years and qualify for indefinite leave to remain. You can't normally combine completely different types of visas. So if you do find yourself in a situation where you're in a particular route, you've moved into it, you really do need to keep your head down and complete 5 years in that route before you qualify for indefinite leave to remain. But thank you very much indeed for that question. Another question again that we've got for the skilled worker visa is in relation to salaries. And the question that's come in is if under the new rules you are offered skilled work and your employer has confirmed that they are prepared to sponsor you, what is the income that you need to show now? I understand that this might have changed. That is correct. There are a lot of people now getting skilled worker visas. The problem is this, that in April, the position changed. Previously, your income had to be, if you're 26 or over, generally speaking, it's around the £26,000 mark, 26,500 if I can remember correctly. If, however, you are a new entrant, you could have been offered a salary of approximately £22,000 to £23,000. The problem now now is the law relating to salaries has changed since April. If you're a new applicant coming into the skilled worker category now, generally speaking, it's going to be either, if you're over the age of 26, you're not a new entrant, etc., the general salary threshold that you're going to have to meet is £38,700. It's a huge jump from the £26,500 category that we had before. If you're a new entrant, because you're under the age of 26, you're a student, you're a graduate, or you've got a job where it's a shortage occupation post, then the salary is going to be lower. It's going to be around just under £31,000. But again, that's still significantly more than what we've had before. So in answer to your question, it depends on your circumstances. It could be 38,700. It could be around £31,000. And indeed, if you're coming on one of these healthcare visas, it could be that your salary is around the £23,000 mark. So a lot depends on your circumstances in terms of the salary that the employer has to offer for you to be able to qualify for a skilled worker visa. If your employer gets the salary wrong, then the problem is that the skilled worker application will, in that situation, be refused. So I think the trick now with these skilled worker visas is not the sponsor license, but to actually successfully navigate the different guidance, the different rule changes that we have in relation to salary, job title, etc. Hope that helps. Inshallah, that we'll be back next week. That brings us to the end of the show. Inshallah, see you again next week. Assalamu alaikum.
Sainsbury's. Oh, we made our money.
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses.